Hello everyone, and welcome to today's free talk, which will be about data protection. My name is Debjani Biswas-Hawkes, and I'm one of the programme officers here on the Not-for-Profits programme at LawWorks. We're delighted to be joined by Peter Parker. Hi, Peter, who's a partner in the Charities and Social Economy Team at Wrigleys Solicitors. And Peter will be talking to us about the importance of data protection, specifically in the context of charities. Peter, welcome. And if I could start by asking you, what is data protection and when does it apply?
Good morning. Data protection is about the fair and proper use of information about people. It's part of the fundamental right to privacy, really. But on a more practical level, it's about building trust between people and organisations. It's about treating people fairly and openly, recognising their rights to have control over their own identity and their interactions with others, and I suppose striking a balance with the wider interests of society. The UK data protection regime is set out in the Data Protection Act 2018 and something called the UK GDPR. It used to be governed by the Data Protection Act of 1998, which was replaced in 2018 by the GDPR, which was a European regulation having direct effect in the UK, and it gained a lot of headlines for the significant fines that could be levied by data protection authorities arising from breaches. So maximum fines could be up to 20 million euros or 4% of the organisation's annual global turnover, whichever was greater. The UK GDPR replaced the GDPR on the 1st of January of this year, 2021, following the end of the Brexit transition period, but it is very, very similar to the GDPR. I would have said that the UK GDPR is the core of the UK data protection regime, with the Data Protection Act 2018 setting out certain derogations to its provisions. The regime will apply to organisations where they have information about people for any business or any non-household purpose. The law applies to any processing of personal data and will catch most charities, whatever their size. So a charity understanding what processing and what personal data means for these purposes is therefore very important.
Great, thanks, Peter. And can I just ask then, what are the key concepts?
So personal data means information about a particular living individual. In the context of a charity, this might be anyone, including a beneficiary, an employee, a trustee, a member, a supporter, or a donor. And it doesn't have to be private information. Even information which is public knowledge or is about somebody's professional life can be personal data. It doesn't cover truly anonymous information, but if you could still identify someone from the details or by combining it with other information held, it will still count as personal data. Almost anything a charity does with data counts as processing, including collecting, recording, storing, using, analysing, combining, disclosing, or deleting it. In addition to what constitutes personal data and processing, there are a number of other important concepts which will feature across this talk. A controller is the person that decides how and why to collect and use the data. The controller must make sure that the processing of that data complies with data protection law. A processor, on the other hand, is a separate person or organisation, not an employee, who processes data on behalf of the controller and in accordance with their instructions. Processors have some direct legal obligations, but these are more limited than the controller's obligations. And processors tend to be providers of administrative type functions. For example, a payroll provider would be a processor to an employer who would be a data controller. If you are processing personal data, you have to be either a controller or a processor. A data subject is a living individual whom particular personal data is about. And finally, the ICO, or the Information Commissioner's Office, is the supervisory authority for data protection in the UK.
Thanks, Peter. So I guess the next question is, what are the key principles behind the UK's data protection regime?
So Article 5.1 of the UK GDPR sets out 7 key principles which lie at the heart of the UK's data protection regime. Aware of only one thing, charities should familiarise themselves with these principles. The principles are as follows. Personal data must be, firstly, processed lawfully, fairly, and in a transparent manner. Secondly, personal data must be collected for specified, explicit, and legitimate purposes and not further processed in a manner which is incompatible with those purposes. Next, personal data must be adequate, relevant, and limited to what is necessary in relation to the purposes for which they are processed. Personal data must be accurate and, where necessary, kept up to date. It must be kept for no longer than is necessary for the purposes for which it is processed. And finally, personal data must be processed in a manner that ensures appropriate security of personal data using appropriate technical or organisational measures.
Okay, so why are the principles important?
Well, they really lie at the heart of the UK GDPR. They're set out right at the start of the legislation and inform everything that follows. They don't give hard and fast rules, but rather embody the spirit of the UK data protection regime. And as such, there are very limited exceptions. Compliance with the spirit of these key principles is therefore a fundamental building block for good data protection practice by charities. It is also key to compliance with the detailed provisions of the UK GDPR, some of which we'll look at later. Failure to comply with the principles may leave charities open to substantial fines. Article 83(5) of the UK GDPR states that infringements of the basic principles for processing personal data are subject to the highest tier of administrative fines. This could mean a fine of up to £17.5 million or 4% of a charity's total worldwide annual turnover, again, whichever is higher.
So definitely not one to be ignored then. And with that in mind, how does a charity go about using someone's personal data lawfully?
So the UK GDPR has the concept of a lawful basis, and it sets out 6 ways in which an organisation can process a data subject's personal data lawfully alongside one of these 6 lawful bases. The lawful bases are set out in Article 6 of the UK GDPR, and at least one of these must apply whenever a charity processes personal data. So there is a premium on charities identifying which one of these lawful bases they are relying in relation to an individual processing activity. Firstly, consent. This is where the individual is given a clear consent for the charity to process their personal data for a specific purpose. Secondly, contract. This is where the processing is necessary for a contract the charity has with the individual, or because they being the individual, have asked the charity to take specific steps before entering into a contract. Next, legal obligation. This is where the processing is necessary for the charity to comply with the law or legal obligation to which it is subject, not being a contractual obligation. Vital interest. This is where the processing is necessary to protect someone's life. Next, public task. The processing is necessary for the charity to perform a task in the public interest or for its official functions, and the task or function has a clear basis in law. This is unlikely to apply, I would suggest, in relation to many charities who will not be public authorities. And finally, legitimate interests, which is often the most hotly talked about basis. This is where the processing is necessary for the charity's legitimate interests or the legitimate interests of a third party.
Okay, so presumably for certainty's sake, charities should just have capture a catch-all quick consent from all the data subjects whose personal data they process.
Well, I'm afraid not. I wish it was that simple. The UK GDPR actually places a high standard for consent, which means that in order for consent to qualify, it must be freely given, unambiguous, and involve a clear affirmative action by a data subject, i.e. a positive opt-in, signing something, ticking a box, that sort of thing. The legislation specifically bans pre-ticked or opt-in boxes, and it also requires distinct or granular consent options for distinct processing operations. So you'd have to consent for each individual processing on which consent was being relied. Consent should therefore be separate from other terms and conditions and should not generally be a precondition of signing up to a service. As an employer, being in a position of power, a charity may find it more difficult to show that it has captured a valid, freely given consent from its employees. So I would have suggested, therefore, that consent is appropriate if you can offer people real choice and control over how you use their data and want to build their trust and engagement. But if you cannot offer a genuine choice, then I would suggest that consent is not appropriate. If you would still process the personal data without consent, then asking for consent is somewhat misleading and probably inherently unfair. I wouldn't say that consent is inherently better or more important than the alternative basis. So if consent is difficult, you really should consider using an alternative basis. There are a couple more things I'd say about consent which might dissuade charities from using and relying on it, and which they certainly do need to be aware. Firstly, the UK GDPR gives a specific right for data subjects to withdraw their consent. You, the charity, need to tell people about their right to withdraw and offer them easy ways to withdraw consent at any time. If they withdraw their consent, you can no longer process their data unless you're able to rely on another lawful basis. Secondly, a consent doesn't last forever and will need to be refreshed from time to time, although when that happens will depend on the circumstances. Thirdly, you must keep records to evidence consent. Who consented, when, how did they do it, and what they were told at the time. This will be a significant administrative burden for charities who are relying on consents.
Brilliant, thanks Peter. Now, I've heard a lot about the legitimate interest basis and that it's the most flexible lawful basis. So could you tell us a little bit more about that, please?
Absolutely, yes. This is probably the most hotly talked about lawful basis, if that's the right expression. The legitimate interest basis can basically be broken down into a three-part test, which is often referred to as a legitimate interest assessment, which is an important concept for charities to be aware of. So the first element of that test is known as the purpose test, where you have to identify, are you pursuing a legitimate interest? And I would have suggested that charities should ask themselves the following question in order to see whether this test is satisfied. Why do you want to process the data? What are you trying to achieve? Who benefits from the processing? In what way? Are there any wider public benefits to the processing? How important are those benefits? What would the impact be if you couldn't go ahead? And would you use the data in any unethical or unlawful way? The next test is the necessity test, i.e., is the processing necessary in order to achieve that purpose? And by necessary, I suppose I mean that the processing must be a targeted and proportionate way of achieving the purpose. Charities should ask themselves the following question. Does the processing actually help to further that interest? Is it a reasonable way to go about it? Is there another less intrusive way to achieve the same result? And then finally, the balancing test, which is probably the most difficult bit. This is where the charity should ask themselves, do the individual's interests override the legitimate interest that's been identified? If the answer to this is yes, then you should not process the person's personal data. If they would not reasonably expect you to use data in the way proposed, or it would cause them unwarranted harm, their interests are likely to override yours. If you are not sure about the outcome of the balancing test, it may be safe to look at another lawful basis.
Okay.
A wide range of interests may be legitimate interests, and the UK GDPR specifically mentions a number, including the use of client or beneficiary data or employee data, marketing purposes, fraud prevention, or IT security. But this is far from an exhaustive list. Importantly, they can be the charity's own interests, or they can be the interests of third parties, and commercial interests, as well as wider societal benefits. I think it is fair to say that legitimate interest is the most flexible lawful basis, but as I hope I've demonstrated above, a charity cannot assume that it will always be appropriate for all of its processing activities. Legitimate interest is most likely to be appropriate where a charity uses data in ways that people would reasonably expect that would have a minimal impact on their privacy. Where there is an impact on individuals, it may still apply if you can show that there is even more compelling benefits to the processing compared to the impact that it would have, and therefore it can be justified. Legitimate interest will not often be the most appropriate, basis for processing, which is unexpected or high risk. In addition, a charity should avoid using legitimate interests if it is using personal data in ways people do not understand and would not reasonably expect, or if they think some people would object if they explained it to them. Just coming back to the legitimate interest assessment finally on this section, you must keep a record of your assessments and the outcome. It should be kept under review and refreshed if there is a significant change in the purpose, nature, or context of the processing being undertaken.
Brilliant, thank you, Peter. Now, you did mention above that legitimate interests can be used by charities for marketing purposes, but I understand there's been a lot of debate in this charity sector about whether charities can only market to individuals who've given their consent. So could you just tell me a bit more about that, please?
Yes, absolutely. This is an area that charities have had difficulties and on occasion have got it wrong. And the confusion arises because of a second piece of legislation that works alongside the UK data protection regime when it comes to electronic communications, such as calls or emails, and which are often used by charities and indeed other organisations for marketing purposes. This second piece of legislation is known as the Privacy and Electronic Communications Regulation. And I think the position is broadly as follows. So in relation to business marketing, this is where a charity is targeting a business, but they may be targeting that business through an individual and indeed using that individual's corporate email account. The contact, the individual, can be sent the direct e-marketing provided they are given the opportunity to opt out in all communications. So in processing any personal data in this way, the charity will be relying on legitimate interests of undertaking the marketing activity. In relation to commercial promotions to individuals relating to services that the charity may have previously provided to them, or services which are similar to those services, charities can what they call soft opt-in those individuals to being sent direct e-marketing. This means effectively the charity is consenting on behalf of the individual concerned. However, the individuals must be given the opportunity to opt out in all communications, and in processing any personal data, the charity will be relying on legitimate interests, again, similar to business marketing. However, finally, in relation to any non-commercial promotions to individuals undertaken by charities, which might include fundraising, it is highly likely that those individuals will have to have consented to being sent direct e-marketing in processing any personal data. The charity will therefore be relying on consent. Finally, I would say that postal communications is not caught by the Privacy and Electronic Communications Regulation. So the only thing that charities need to think about in these circumstances is their data protection law compliance.
So do the same rules apply to all types of personal data? For example, is someone's name regarded in the same way that details about their health would be?
No, that's not the case. The UK GDPR has additional requirements in relation to the processing of what it defines as special category data, otherwise known as sensitive personal data. And this is personal data revealing the racial or ethnic origin of a data subject, their political opinions, their religious or philosophical beliefs, any trade union membership, genetic data, biometric data, or data concerning that person's health, sex life, or their sexual orientation. Given their work, many charities will routinely process special category data, particularly in relation to their beneficiaries. So in doing so, in addition to ensuring that processing is lawful by identifying an Article 6 lawful basis for processing it, a charity can only process special category data if it can meet a specific condition, essentially a further basis, in Article 9 of the UK GDPR. This in effect means that a charity has two hoops to jump through in connection with the lawful processing of special category data. The Article 9 conditions include where the data subject is given explicit consent or the processing is necessary for reasons of substantial public interest with a basis arising in law. That meaning that you would also need to meet one of 23 specific substantial public interest conditions set out in Part 2 of Schedule 1 of the Data Protection Act 2018, an example including the prevention or detection of unlawful acts. Whilst criminal offence data does not constitute special category data, the UK GDPR gives extra protection to personal data relating to criminal convictions and offences or related security measures. So this therefore covers a wide range of information about criminal activity, allegations, investigations, and proceedings. In addition to ensuring that processing is lawful by identifying an Article 6 lawful basis for processing it, a charity can only process criminal offence data if it is able to meet one of the conditions in paragraphs 1 to 37 to Schedule 1 to the Data Protection Act 2018. And again, this would include circumstances where the charity is seeking to prevent or detect an unlawful act.
Thanks for going into detail about that, Peter. That's really useful, actually. And just moving on slightly, I've heard a lot about data subject access requests. So could you tell us a bit more about these and the other rights of data subjects, please?
Of course. The UK GDPR provides the following rights for individuals. The right to be informed, the right of access, which is access through a data subject access request that you just referred to, the right to rectification, the right to erasure, the right to restrict processing, the right to data portability, so that's a right to transfer data between organisations, the right to object to processing, and then finally rights in relation to automated decision making and profiling that may be made by an organisation. The right to be informed is perhaps the most important right from the point of view of an organisation which processes personal data and the administrative actions that they will need to take. Articles 13 and 14 of the UK GDPR specify what individuals have the right to be informed about. What and when you need to tell people differs slightly depending on whether you collect personal data from the individual it relates to or you obtain it from another source. This information is usually provided in an organisation's privacy notice or privacy policy, which is made available to data subjects and makes up one of the most important documents that organisations will maintain from a compliance point of view. You must actively provide privacy information to individuals. You can meet this requirement by putting the information on your website, but you must make individuals aware of it. For example, signposting them back to your website at relevant points in your communication with them. And you must give them an easy way to access the privacy policy. We're often asked by charities as to how they should go about drafting their privacy notice. The first place to start is by undertaking an information audit or data mapping exercise, which will help them understand what personal data they hold and what they do with it, and then refer to all of those things in the privacy notice. It's important to think about the intended audience for your privacy notices. If a charity collects or obtains children's personal data, they must take particular care to ensure that the information they provide them with is appropriately written using clear and plain language. For all audiences, charities must provide information to data subjects in a way that is concise, transparent, intelligible, easily accessible, and uses clear and plain language. This might mean that a charity maintains a number of privacy notices, for example, one for employees and one for beneficiaries. This is to ensure that they are relevant and that they are easy to read. After they're finalised, charities should undertake regular reviews of their privacy notices to check that they're accurate and up to date. And if charities plan to use personal data for any new purpose, they must update their privacy information in their privacy notices and then proactively bring any changes to people's attentions.
Brilliant. So we've just learnt that privacy notices are an extremely important part of a charity's data protection compliance. Can you tell me about other steps a charity should be taking to ensure that they're complying with the relevant data protection laws?
While the UK GDPR does not specify an exhaustive list of things charities need to do in order to be accountable, it does set out several different measures they can take that will help them get there. So we've set out below what we think is a non-exhaustive list of some of the key measures. Firstly, data protection policies. For many organisations, putting in place relevant policies is a fundamental part of their approach to data protection compliance. The UK GDPR explicitly says that where appropriate, implementing data protection policies is one of the measures you can take to ensure and demonstrate compliance. What you have policies for and their level of detail depends on what you do with personal data. If, for example, you handle large volumes of personal data or particularly sensitive information, such as special category data referred to earlier on, then you should take greater care to ensure that your policies are robust and comprehensive. You should be able to show that you have implemented and adhered to your data protection policies. So this could include raising awareness, training, monitoring, and audits in your organisation. Secondly, data protection by design and default, and I would put with this data protection impact assessments, or what are often called DPIAs. This is all about embedding data protection into everything you do throughout all your processing operations, including when designing new products, processes, and systems that use personal data. The UK GDPR legally requires you to take this approach and suggest measures that may be appropriate, such as minimizing the data you collect, applying anonymization and pseudonymization techniques, and improving security features. In some circumstances, organisations are required to undertake data protection impact assessments, or DPIAs, including before carrying out processing likely to result in a high risk to individuals' interests. A DPIA is essentially a written risk assessment which helps organisations identify and minimise the data protection risks of any new products or projects that they undertake. DPIAs are a key part of taking a data protection by design approach. The next step to take is use of contracts. So whenever a controller, referred to earlier on, uses a processor to handle personal data on their behalf, it needs to put in place a written contract that sets out each party's responsibilities and liabilities. Contracts must include certain specific items as a minimum, such as requiring the processor to take appropriate measures to ensure the security of processing and obliging it to assist the controller in allowing individuals to exercise their rights under the UK GDPR. Whilst there's no legal obligation to do so, it would be best practice to put in place a contract between two data controllers where they're sharing significant amounts of personal data regularly between one another. Using clear and comprehensive contracts helps to ensure that everyone understands their data protection obligations. Fourthly, written records of processing. Under Article 30 of the UK GDPR, most organisations are required to maintain a record of their processing activities, covering areas such as processing purposes, data sharing, and retention. Knowing what information you have, where it is, and what you do with it makes it much easier for you to comply with other aspects of the UK GDPR, such as making sure the information you hold about people is accurate and secure. Fifthly, security measures. The UK GDPR requires organisations to implement technical and organisational measures to ensure a level of security appropriate to the risk. You need to implement security measures if you are handling any type of personal data, but what you put in place depends on your particular circumstances. So you need to ensure the confidentiality, integrity, and availability of the systems and services you use to process personal data. Amongst other things, this may include information security policies, access controls, security monitoring, and recovery plans. And lastly, data protection officers, or DPOs. Some organisations are required to appoint a DPO. A DPO's tasks include advising their organisation about the UK GDPR, monitoring compliance and training staff. Your DPO must report to your highest level of management, operate independently, and have adequate resources to carry out their tasks. Even if a charity is not obliged to appoint a DPO, it is very important that they have sufficient staff, skills, and appropriate reporting structures in place to meet their obligations under the UK GDPR. Ultimately, this will mean that somebody in your charity or your organisation needs to have somebody who is responsible for data protection compliance and overseeing it.
Understood. And just taking that a bit further, presumably it's really important to demonstrate accountability if things do go wrong.
That's absolutely right, and unfortunately they are bound to go wrong, and that this is probably none more so the case than if a charity suffers a personal data breach. A personal data breach means a breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of, or access to personal data. This includes breaches that are the result of both accidental and deliberate causes, and it also means that a breach is much more than just about losing personal data. A charity must report certain types of personal data breach to the Information Commissioner's Office, or the ICO. and in some circumstances to the affected individuals as well. Where a personal data breach has occurred, the charity needs to establish the likelihood of the risk to people's rights and freedoms, which may be financial, physical, or mental, such as emotional distress. If a risk is likely, the charity must notify the ICO within 72 hours. If a breach is likely to result in a high risk to the rights and freedoms of the individuals concerned, for example, a risk of fraud, the UK GDPR says the charity must inform those concerned directly and without undue delay, i.e. as soon as practically possible. Additionally, the UK GDPR says that you must keep a record of any personal data breaches, regardless of whether you needed to report them or not. You need to be able to detect, investigate, report both internally and externally, and document any breaches. So having robust policies, procedures, and reporting structures will help you greatly with this.
Brilliant, Peter. Thanks so much for that. And I'm conscious that even if they don't actually realise it, many charities might be sharing data outside of the UK. So can you tell us a bit about how they could go about doing this without being in breach of the law?
That's right. Many organisations can find themselves in these sort of circumstances, and many of them don't realise they're doing this at all. It will happen if, for example, their data on their IT systems is held in a data centre outside of the UK, which may be far from their minds when they're implementing the contract with the relevant IT provider. So something to think about. This ultimately, though, is not just an issue for large international charities. So why is it important to know whether this is the case? Well, individuals risk losing the protection of the UK GDPR if their personal data is transferred outside of the UK. So the UK GDPR then restricts the transfer of personal data to countries outside the UK or to international organisations, and this is known as a restricted transfer. These restrictions apply to all transfers, no matter the size of transfer or how often you carry them out. You may make a restricted transfer if the receiver is located in a third country or territory, or is an international organisation covered by something called the UK Adequacy Regulations. The UK Adequacy Regulations set out in law that the legal framework in that country, territory, sector, or international organisation has been assessed as providing adequate protection for individuals' rights and freedoms to their personal data. There are provisional arrangements so that the UK Adequacy Regulations include the European Economic Area and all countries, territories, and international organisations covered by the European Commission's adequacy decisions, valid as at the 31st of December 2020, i.e. the end of the transition period. If there are no UK adequacy regulations about the country, territory, or sector for your transfer, you should find out whether you can make the transfer subject to appropriate safeguards set out in the UK GDPR. They include if you and the receiver have entered into a contract incorporating standard data protection clauses recognised or issued in accordance with the UK data protection regime. The standard contractual clauses, or SCCs as they're sometimes called, contain contractual obligations on you, the data exporter, and the receiver as the data importer, and the rights for the individuals whose personal data is transferred. Individuals can directly enforce those rights against the data importer and the data exporter. Finally, if you're making a restricted transfer that is not covered by the UK adequacy regulations, nor an appropriate safeguard, then you can only make that transfer if it is covered by one of the exceptions set out in Article 49 of the UK GDPR. Exceptions include where the individual has given his or her explicit consent to the restricted transfer.
Brilliant. Well, that brings us to the end of the talk. So Peter, I just can't thank you enough for this. It's been really interesting and really informative. I know that all of our not-for-profits will be really appreciative of it, and it will be really useful to them. And just to say that there have also been a number of other free talks filmed a little bit earlier last year by some of your other colleagues at Wrigleys. But thanks again for being here with us, Peter.
No, thank you ever so much.